everyone. Ooh, there's a little bit of an echo there. Sorry about that. But hi, everyone. Welcome to Sterling Live. My name is Caitlin Brower. I am Sterling's social media manager. Sterling Live is our weekly live series where we come, to you on Facebook, LinkedIn, and YouTube with, just great awareness, thought leadership, some great guests as well. So I'm really excited to be back for another episode. And more importantly, I'm really excited to be here today with Angela Preston. So she is our guest today. So welcome, Angela. For our audience, Angela is our SVP and Counsel for Corporate Ethics and Compliance. Angela is here today because we do have a very, important topic, a very timely topic to discuss. We are going to be talking about certain things going on within Michigan right now and making sure that we keep those workplaces safe. So before we dive into the topic a little bit more, Angela, can you please introduce yourself to our audience?
Sure. Hi, Caitlin. Thank you for hosting today. Glad to be back for another LinkedIn Live. And so as you mentioned, my role at Sterling is really overseeing all things compliance, part of the legal department. I am an attorney, but don't hold that against me. We have a great compliance team at Sterling, and my role is to oversee our initiatives to make sure that we're following laws, regulations, best practices in the industry. We track legislative changes, regulatory changes that affect the industry and certainly affect our operations as a company. We are in a very regulated space with background screening services. We're regulated federally by the FTC and the CFPB. So we have to follow federal laws like the Fair Credit Reporting Act, as well as a number of state laws that impact the reporting of background screening information. Not only that, but we also understand that our clients have a lot of legal compliance and regulatory issues that they need to keep up with. So, part of our role is really being that connection for our clients to everything that's happening from their perspective as well, with respect to complying with laws and different regulations. And even when something isn't maybe a black and white, black letter law, there are certainly best practices that we keep abreast of and certainly keep track of and share that information with our teams internally and also with clients. Mm-hmm. We do a number of resources and publish a lot of resources, blogs, conduct webinars and that sort of thing, all to sort of keep everybody up to date on this very rapidly changing world of background screening compliance.
Mm-hmm. Well, thank you for that. And yes, a lot of important thing that you and your team do. So thank you, as always for that. As mentioned earlier, I'm going to introduce our topic today. So we're talking about keeping Michigan workplaces safe. So let's go into, exactly what that means and everything that we're going to explain to everyone today. So I do want to just quickly remind our audience, if you have questions for Angela throughout the show, we are live on Facebook, LinkedIn, and YouTube. So just go ahead and put your questions in the comment section across all three of these platforms, and I'll get them over to Angela as I see it fit throughout the show. So let's go ahead into the questions that I have for you. I have a couple of questions in regards to this. So, we're talking about keeping Michigan workplaces safe. What does that mean? So my first question for you is, Angela, can you please explain the potential new Michigan court rule that would require redaction of date of birth from court records?
Yes, yes. And that really is the topic of the day, because keeping Michigan workplaces safe is really sort of the overriding goal in terms of what we do when we do background checks for prospective employees or employees anywhere in the country or in the world. Part of our goal of doing a background check is really to keep workplaces safe. Mm-hmm. That is part of our mission and why we exist as a screening company, to serve employers and to help workers be in a safe environment. And it's proven that by conducting a background check, that is one proactive step that you can take in order to identify potential threats to the workplace. And background checks are required by a lot of industries, and there's certainly, at one point they may have been sort of an optional thing to do, but they've really become a business imperative because it's been proven that that is a reliable predictor and a way to prevent violence, theft, or just in general promote safety in the workplace. And part of the need for background checks is really focused on looking at criminal history and court records. We rely on the courts in making their public record information available to us, to the public, not just to background screening companies, but it is a matter of making that public record available to us. And that is an element of what we use in our background screening process. So part of that public record is all of the pieces of information that we need in order to sort of positively identify that a court record is associated with a candidate or an employee when you're doing the background check. We need to make sure that we get it right, and we need to make sure that the information that we provide is accurate. And so there is an initiative that was really started in the state of Michigan by the Supreme Court of Michigan and through the Michigan State Court Administrator's Office. They are an administrative agency that is charged with taking care of the administrative functions of the court. And that initiative was really part of an e-filing initiative. And that e-filing initiative, there was part of that initiative that actually sought to protect personal information, protect people from identity theft, and for very good reasons, I think, intent-wise, to take into consideration the privacy of individuals. And part of that e-filing initiative that began a couple of years ago as a pretty big initiative by the Supreme Court in Michigan actually turned out to have the effect of putting a rule in place that would remove identifiers from the court record. And I pause there because that is a significant change to the status of accessibility and the whole concept of court records being public and available to the public. So this court rule really had an unintended, I believe, an unintended consequence of removing personal identifiers and specifically date of birth information from court records in Michigan, which would have a devastating effect and impact on the ability to use that court information to connect or relate to and identify whether or not a record is associated with a candidate in the background screening process.
Right.
So that court rule is really what we're talking about today in terms of trying to keep Michigan safe. We are looking at this from a background screening perspective and saying, hey, wait a minute, time out. If you put this court rule into effect, we are not going to be able to necessarily associate that record or positively identify records with candidates, which will be a huge step backwards in terms of being able to conduct a background check. In some cases, you may not be able to conduct a background check at all, which puts employers in a terrible position in the state of Michigan. Employers who rely on companies like Sterling and many other companies that are providing this very valuable service and really serving a much greater public policy of the need to keep workplaces safe and help employers comply with other laws that require them to do background checks. So, so really, the awareness of this court rule really came about once we were made aware that this rule was actually going to have the impact of removing that court record or those date of birth records from court records. And once we became aware of that, we did get involved through our trade associations, the Professional Background Screeners Association and the Consumer Data Industry Association, which are the trade associations that oversee or represent background screening companies and help promote best practices in background screening. And Sterling has engaged through both CDIA and PBSA to really fight back and say, look, we really need this information, and we're doing this program today in part to make employers and clients aware that this is a very serious issue that needs to be addressed and needs to be supported. The court rule, the proposed court rule, was put into effect and then rolled back once they realized that there were going to be issues with implementation. But if it's not stopped, it will go into effect January 1st of next year. And so that's just a few weeks away, essentially, in terms of action and really trying to get this rule stopped. We really have a very short time frame in terms of just trying to reach out and make the public aware.
Yeah. So you touched briefly on, the impact on employers, and making sure that, through the background screening process, the candidates and everything, this could be a potential impact there. So who else, is this, can this potentially impact in the future?
Well, I think that it can impact, not only employers, but anyone that is relying on the public record and that information. When you think about the economy, like the gig economy, where individuals are, they have to be screened in order to participate in platforms like a gig platform. Healthcare workers and hospital workers who have to be screened in order to serve in their positions. The public, who are, the vulnerable populations who are under the care of those workers, are at risk in, if you're not able to conduct a thorough background check, do you really want to entrust, your loved one who is, maybe an elderly family member, or your child going to an athletic program where the coach maybe has not been screened, or daycare providers that can't be thoroughly screened? So it really is an issue that has a broad impact on lots of people that would potentially, would benefit from that information being available and continued access to that through the courts.
Got it. So the interesting thing is here, so, and I would like, our audience to have a little bit more detail on it. So the reason, people want this for privacy, but, in fact, date of birth is public facing. So, certain groups like victims groups, things like that. So can you provide our audience just with a little bit more detail around that, like this specific scenario?
Yeah, certainly we don't want to do anything that would put victims groups at risk. And the approach that, again, we've been working through the Professional Background Screeners Association as well as the CDIA to, try to reason with the court in not having that rule or rolling back that rule. And while they've delayed the rule, they have not really been, have not committed to a change to the rule. So the associations have taken a different approach of going to the legislature. And so this is sort of a long-winded way of answering your question, but in the legislature, we have, we being the trade associations, have worked with a sponsor, Representative Filler in Michigan, in the House, who sponsored a bill to make a legislative change that would specify that court records are public, and specifically date of birth cannot be redacted, name and date of birth, because name and date of birth are part of the public record. They are traditionally recognized as public information. And while we do recognize the concern, there is no other state in the country that does not recognize date of birth and name as part of the public record. In 50 states where we have had, historic relationships with courts and have enjoyed access to the public record, and it is a First Amendment issue as far as this being public information, that we have not seen this kind of step taken in any other state or legislature. So we've gone to the legislature. The legislature has introduced a bill, and we are proposing that the language be limited to that date of birth and name must be made available for defendants. And that would address concerns that maybe victims could not be protected, because we would want victims of crime to be able to protect their information and make that non-public. So I think that we are being very thoughtful in terms of trying to have an approach that will protect people's interest in privacy, but yet still make the information available that is needed in order to do our jobs and to do what employers need to do to comply with their obligations, not only under law, but to their employees, to people, which is key here. So, so again, we are taking this sort of many approaches to this, and we certainly welcome employers, whether you're a client of Sterling or not, it doesn't really matter. We are encouraging people to get involved and go to the PBSA website, where there's a petition where you can engage and sign on to support this effort. Because as I mentioned, the clock is ticking. We are trying, the PBSA and CDIA are along with a coalition of other folks. I want to make sure that people understand this is not just background screening companies gathering together. There is a coalition, including the Michigan Chamber, and a number of organizations who have signed on in support. The legislation that I mentioned passed out of the House Judiciary Committee last week. There was a hearing. It passed without any objection, no nay votes. And there is widespread support in the business community, as well as different victims groups who have been the victims of crimes committed in the workplace by folks who weren't properly background screened.
Right.
So there is very much, sort of a growing body of support for this legislation. We would certainly hope to be able to work things out with the Supreme Court's administrative office. And we continue those conversations, because that type of resolution would be ideal. I think everyone agrees, but if we're not able to resolve things through that sort of a compromise, we need to move forward in the legislature to try to make this the law of the land in Michigan.
So what does all of this mean in like a more broad context. And for example, similar to some situations that are happening out in California.
Yeah, so we see, as sort of part of this initiative, I'll sort of paint it with a broad brush to say that, there are a lot of privacy concerns, very well-founded concerns about identity theft, and folks who are concerned about information being used in a way that might be prejudicial to certain groups, and potentially even discriminatory practices that might come out of the use of some types of court information. And as a result of that, we do see in some areas that courts, or through litigation practices, some folks are pushing to remove identifiers from public record.
Mm-hmm.
And, we've seen a court case in California that, was successful in one particular district to, kind of through litigation, have a court rule that they believe that certain information personal information should be redacted or not made available by the court clerk. And so, I would say that we are starting to see a trend of people coming forward to question whether or not all of this information should be publicly available. Most of those efforts, don't take into consideration the proper use of that information and the need to have access to that information in order to do things like background checks, which promote a very valuable public policy goal of keeping the public safe. So we do see sort of a trend of this, redaction or limitation by the courts and making that information available. So again, it's very important for those of us who understand the nuance and the need for this from a business perspective, from a safety perspective, that we engage and ensure that we continue to have access for what is a very critical public policy need for safety.
Yeah, it's a really important overview.
Your question?
No, it did. It definitely did. Because you're tying both like instances together, but you're also bringing up there is this kind of common trends that we kind of seeing now, could be seeing. So you definitely answered my question for sure. So, everything so far within the episode has been great. A really good overview, kind of where Sterling is with this, what, our audience can do and everything like that. We did go over a decent amount over the last 21 minutes or so. So if our audience, you have any questions for Angela, please, send them in. You can follow up with us after the show as well. But I do, as we wait for any potential questions to come in, I do, want to just get some final thoughts from you. I know we positioned ourselves nicely on the show so far, but kind of just like high level view of like what our actual stance is and like anything else you want to leave our audience with.
Yeah. So, I think that the main point of today's show was really awareness around this issue. It is very much a live issue in the state of Michigan. The clock is ticking. As of January 1st, there may not be date of birth information available in the court record as a matter of court rule. And that is a serious situation for employers and for the public. And so we wanted to sort of ring the bell, and we do have a way that people can participate and engage through a petition that's being circulated by the PBSA. We can provide that link and information about that petition. And people can also contact Representative Filler in Michigan, Filler, Republican in Michigan. He has a lot of information available on his website, and CDIA has some resources available. So there's information out there that we can provide if folks want to engage on the issue. So the thing that we really wanted to do today was promote awareness around the issue, the seriousness of the issue, the critical nature of the issue, and also to, engage in the dialogue with your screening provider. If you are with Sterling, if you're with a different provider, it doesn't matter. Start some dialogue around this issue because it will impact your program. There may be some other sources that we can use. There is a state police database, but the state police, which is called iChat, it doesn't have, it's not a substitute for the court record. It doesn't have the full record, if you will. It has some gaps, and this is something that while it can be a useful tool, it's not a substitute. For example, crimes that don't require at least 90 days of incarceration may not be included in iChat. There may be lower level crimes or people who are charged but not booked into a police facility. If they're just simply charged and given a court date, those folks might not be in iChat. So there are some other resources out there that folks might say, well, you can just use this or that. It's not a substitute really for the court record. The court record is our source of truth when it comes to, really identifying someone's history and court history.
Right. Thank you. So I see a couple of comments. All the links that we're talking about and everything, the information will be provided. So we'll get those up after the show across of our platforms. But yeah, as Angela said, this was really, much of an awareness, episode for everyone. We really just wanted to get out there and make sure our audience really understood what was going on. Also, as Angela said, this is a live happening. This is happening right now. So everything you heard today, is happening, going on. Anything that we can update in the future, we will do our best as well. Please contact us if you have any questions, if you need anything, you want to partner with us on this, to see how everything goes. There are a couple of call to actions as well that you can do as an individual or as an organization. As we said earlier, we will post all the links to all the information and everything, so you can take those next steps if you feel you need to. So yeah, with that being said, Angela, thank you so much for joining me today on Sterling Live. Thank you to our audience who joined us live across Facebook, LinkedIn, and YouTube, and to anyone who's watching us on demand in the future. We do truly appreciate that. We have 2 episodes this week, actually, so I'll be back on Thursday with another timely matter that's going on. So don't miss out. I'll be here again on Thursday. But again, Angela, thank you so much. I really appreciate your insight, as our audience did as well.
All right. Thank you, Caitlin. Thanks, everybody.